If you slip on a wet floor in a supermarket or trip on a broken paving slab at a park, who's actually responsible? Well, the law of occupiers' liability is designed to answer exactly that, and you're about to find out it's definitely not as simple as just blaming the person who owns the place.
This video was created with AI to support SQE1 study. We are independent and have no affiliation with the SRA, Kaplan, or the SQE. We do not share exam content, and our videos are for informational purposes only and should not be used as legal advice. Please check and refer to primary legal sources and recommended prep guides as you study.
Welcome to The Explainer. Tort law is a huge part of the SQE1 syllabus, and today we're going to zero in on occupiers' liability in England and Wales. Let's get this cracked.
So here's our game plan. We're going to start with the absolute basics. Then we'll get into the two massive laws that split everything between lawful visitors and trespassers. After that, we'll look at how occupiers can defend themselves, test what you've learned with some exam-style questions, and then finish up with a super handy checklist for your revision. Okay, let's lay down the groundwork. Before we get into any of the complicated stuff, we need to be absolutely crystal clear on what the law means by two key terms, an occupier and premises. Get these, and everything else makes a lot more sense.
First up, the occupier. Now, the crucial thing to remember for your exam is that the law doesn't care about who legally owns the property. It cares about who has control. The classic case is Wheat v. Edilakon & Co. You had a brewery that owned a pub and a manager who ran it. When a guest got hurt on a poorly lit staircase, the court said, you know what? Both of you had enough control to be considered occupiers. So remember, you can absolutely have more than one occupier at the same time.
And what about premises? Well, the legal definition here is incredibly wide. We're not just talking about a house or a field. The 1957 Act itself says this covers things you might not even think of, like ships, cars, and yes, even a simple ladder. Honestly, for the SQE, just think of premises as pretty much any space or structure a person can be on or in.
Okay, this slide is probably the most important distinction in the whole topic. For any problem question, your very first thought must be, is the injured person a lawful visitor or are they a trespasser? Because the answer to that question sends you down one of two completely different legal paths with totally different rules.
So let's start with that first path, the Occupiers Liability Act of 1957. This is the law that tells us all about the duty an occupier owes to people they've invited or allowed onto their property. In short, they're lawful visitors. Now, the 1957 Act gives us this thing called the common duty of care. This is the core principle. But listen closely to the wording. The duty is to make the visitor reasonably safe, not to make the premises perfectly safe. That's a really important difference. It means the occupier doesn't have to bubble wrap the entire world. They just have to deal with dangers that might unreasonably hurt a visitor.
Now here's where it gets a bit more nuanced. The law is smart. It knows that not all visitors are the same. So this common duty of care gets tweaked for two special groups. For children, the occupier has to do more because, let's face it, kids get into trouble. But for specialists, think an electrician or a roofer, the occupier can actually do less because they can expect that professional to know their job and handle its specific risks.
And we can see this play out in the cases. In Taylor v. Glasgow Corp., a child ate some poisonous berries that looked like cherries, a classic allurement, and the occupier was liable. But then you have Phibbs v. Rochester, where the court said, actually, parents need to watch their very young kids near obvious dangers like a trench. And for specialists, Rolls v. Nather is the go-to case. Chimney sweeps died from fumes they'd been warned about, a risk that was part of their job, and the occupier was not liable.
So, let's imagine this in an SQE question. You see a scenario with an expert, like this electrician. He gets hurt by a risk that is right in the middle of his professional skill set, live wires. Well, in that case, the occupier's duty under Section 2(3)b has almost certainly been met. The law expects the expert to manage the dangers of their own trade. Right, so that's lawful visitors sorted. But what about people who are on the land without permission? That takes us to our second big pillar, the Occupiers Liability Act of 1984, which is all about the duty owed to trespassers.
Now, for an occupier to owe any duty at all to a trespasser, this three-part test must be passed, and it is a very tough test. The occupier has to know about the danger, they have to know that a trespasser might come near it, and the risk has to be something they should reasonably do something about. If a claimant can't prove all three of those things, their case fails right there.
And let's be clear, even if a trespasser manages to get through that three-part gateway, the duty they're owed is pretty limited. It's just a duty of reasonable care in the circumstances to protect them from that specific danger. This is a much, much lower standard of care than the one owed to lawful visitors.
If you remember one case for the 1984 Act, make it Tomlinson. Here, a man saw loads of no swimming signs around a lake, ignored them all, dived in, and tragically broke his neck. The House of Lords came down hard. They said the council was not liable. Why? Because the danger came from the man's own reckless choice, not from the state of the lake itself. This case is huge because it champions the idea of personal responsibility for trespassers who take obvious risks.
So now we know what duties are owed, but how can an occupier fight back against the claim? Let's go through the main defenses they can use.
An occupier has a few options here. They can argue they gave an adequate warning, and note that a simple danger sign might not cut it. It has to be enough to keep the person safe. They could use the defense of consent, also known as valenti, if the visitor willingly accepted the risk, like in the case of Geary v. Weatherspoon, where someone decided to slide down a banister. If the visitor was careless themselves, their damages can be reduced for contributory negligence. And finally, if the harm was caused by, say, a dodgy builder, the occupier can often pass the blame if they can show they hired a competent independent contractor.
And there's one more piece of the puzzle, the Compensation Act of 2006. This is really important. It basically tells judges, hey, when you're deciding if an occupier was negligent, you have to think about the social benefit of the activity. It was designed to push back against a compensation culture and stop useful or fun activities, like having a playground, from being shut down just because there's a tiny element of risk. It's all about finding a sensible balance. All right, time to see what's stuck. Here is a classic SQE-style multiple-choice question. Have a read and really think about the specific rules we've just talked about.
Okay, so what have we got? We've got a specialist visitor, a plumber. But he's not injured by a plumbing problem, he's injured by a rotten staircase. So does that special rule for specialists actually apply here or not?
The answer is B, and if you got that, brilliant. Here's why. That specialist defense is very specific. It only applies to risks that are part of the specialist's job. A dodgy staircase has nothing to do with plumbing. It's a general danger of the premises. So, for that particular risk, our plumber is treated like any other normal visitor and is owed the full common duty of care.
Okay, let's wrap this up and pull everything together into a straightforward checklist you can use to attack any occupier's liability question that the SQE1 throws at you.
Here is your battle plan. Step 1 always is to figure out the claimant's status. Are they a visitor or a trespasser? That tells you which act to pick up. If it's the 57 Act for a visitor, check if they are a child or a specialist. If it's the 84 Act for a trespasser, you must go through that strict three-part test. And then finally, always ask yourself, are there any defenses that might apply? Keep these key cases, Wheat, Rolls, and Tomlinson in your back pocket, and you'll have a rock-solid structure.
I'll leave you with one final thought to mull over. This whole area of law is a balancing act. Has it got that balance right? On one side, we want to protect people from harm. But on the other, as we saw in the Tomlinson case, there's a huge emphasis now on personal responsibility. Where do you think that line should be drawn?